Good afternoon, everyone. Welcome to another employment law Q&A for this Thursday afternoon, June 2nd. We are live right now answering all employment law related and workplace related questions. Now is your opportunity to speak with an employment lawyer. Myself, my name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin LLP. Now is your opportunity to ask any questions you have related to your employment. If you're dealing with a difficult situation at work, if maybe a colleague or a boss is treating you poorly, maybe you've been let go from your job and you've been offered a severance package. Maybe you haven't been offered any kind of severance package at all. Maybe you've been terminated for cause based on an allegation of misconduct or poor performance. Uh, Lots of other examples of workplace situations. Maybe you've been temporarily laid off. Maybe your employer is asking you to take a pay cut. Really, any situation that you are dealing with at work. If your spidey senses are tingling, if you feel like something is wrong, if you feel like you're being mistreated, go ahead and ask your question right now. Ask it in the comments, whatever platform you're watching us on. Go ahead and ask him, and I promise I will get to your question. I will give you the information that you need and get you moving in the right direction with respect to resolving your workplace problem. Workplace issues are stressful. They can affect your health. They can affect your personal time, always worrying about the issue, worrying what's going to happen with your job. Don't let that stress get to you. You need to relieve that stress. And the way you do that is by asking an expert, asking an employment lawyer, and again, getting that situation tackled and resolved. If you don't know what your rights are in the employment relationship, you will not be able to resolve the problem. You will not know what to do in the situation you have. The more information, the more knowledge you have as an employee, the more protected you are going to be at work. And again, the easier you can resolve those workplace problems. So please, guys, go ahead and ask your questions. That's what we're here for. I'm happy to give you a couple of topics that have come across my desk this week and talk about a couple of issues. But really, the main reason I am here today for the next half an hour is to answer your questions. So please don't be shy, don't be bashful. Go ahead and ask your questions, and I promise I will get to you. I see a couple of questions coming through already, so that's absolutely great. Please go ahead and ask away. Before we do that, a couple of pieces of contact information. You see it on your screen right now. The one way that you can get a hold of us primarily is by visiting our website, employmentlawyer.ca. We've got all of our contact information on that website. We've also got a ton of other stuff, blog posts, articles, video clips, really you name it. It should be employmentlawyer.ca should be the starting point. If you have any employment law issues or questions, you can probably find your general issue or question on that website. And again, you can also find our contact information on the website if you want to get a hold of us. If you want a sense of how much severance you're owed, there's a severance pay calculator on the website. Please go ahead and use that. And again, as you saw as well, another way that you can contact us is our email address. Another easy way to get a hold of us, help@employmentlawyer.ca. That's help@employmentlawyer.ca. Again, you see it on the screen right now. Go ahead and send us an email. It's completely confidential. There is lawyer-client confidentiality here. We cannot disclose this information to anyone else other than yourself. Email us a brief summary of your situation. Tell us the situation that you're dealing with, and I promise someone will get back to you. Okay, before we get into the questions, guys, and again, please go ahead and ask away. I spoke to a couple of people this week along a very similar theme, and I wanted to just talk about it briefly because I think it's an increasingly hot topic in the employment law world. I actually just spoke to a gentleman half an hour ago with respect to this issue, and again, I had a couple of other conversations earlier this week about it, and that is medical leaves of absence in the workplace. I speak to people every single day who are having difficulties with their jobs, being let go from their jobs, and I am seeing an increase in employees taking medical leaves of absence, and not only taking medical leaves of absence, but also being punished by their employer because of it. And I'm talking specifically now here in the province of Ontario, and this is generally true throughout Canada as well. But I wanted to lay out some ground rules with respect to medical leaves of absence in the workplace, very basic information that any employee should know of if they have to take some sort of sick leave, if they're medically unable to work, or if they need accommodations in the workplace. These are the ground rules that you as an employee should know, again, when it comes to medical leaves of absence. Number one, an employer has to allow you to take a medical leave of absence, provided that it is doctor supported. So employees out there, if you're going to have to be taking some time off for a medical reason, maybe you're dealing with an injury, maybe you have to have some sort of surgery or some sort of treatment, whatever the medical issue is, get a note from your doctor confirming the amount of time that you need off. The note doesn't need to say what you're dealing with physically. It does not need to disclose the diagnosis of the medical issue that you are dealing with. It needs to provide the prognosis. Prognosis meaning how long are you going to be off for? And so get a note from your doctor, provide that note to your employer. Your employer has to 110% respect that medical leave of absence. You cannot be terminated for taking a medical leave of absence. You cannot be demoted for taking a medical leave of absence. You cannot be punished in any particular way in your employment for taking a medical leave of absence. Otherwise, that's considered discrimination under the Human Rights Code, and employer is going to end up in hot, hot water because of it. So employees, don't be shy to take medical leaves if you need to, but get a note from your doctor confirming how long you need to be off for. That is number one. Don't be shy to take medical leaves of absence if you need to. Your health, both mental health and physical health, remain your priority. However important your job is, whatever role or position you're in, your health has to take priority, and don't be shy to speak to your employer about taking a medical leave of absence. Basic point number two. If you need accommodations in the workplace because of a medical situation. And again, guys, this could be either a mental health issue or a physical issue. You are allowed as an employee to ask for accommodations, provided, again, that your doctor supports your claims. For example, if you work a very physically demanding job, and you are having physical health issues, maybe you can't lift as much as you used to, or maybe you're having particular issues with your shoulders or your knees, get a note from your doctor with some very specific requirements and accommodations that you need. Maybe you need to take more breaks during the day. Maybe you can't lift over a certain weight. Your doctor needs to specify those in a note. Provide that note to your employer. Your employer has, again, a legal obligation to accommodate your physical limitations up to the point of what's called undue hardship. Undue hardship is a very, very high bar. Your employer effectively, it has to be nearly impossible for your employer to accommodate you in order to say no. 9.9 out of 10 times, your employer has to play ball and accommodate your limitations within the workplace. Again, this can look like anything provided it's doctor supported. Maybe you need, again, a number of breaks during the day. Maybe you can only work a certain amount of hours per day. And again, maybe there are specific things in your job that you can or can't do. Again, provided you have the support of your doctor, you have every right to ask your employer to accommodate those limitations. And even if it's difficult for your employer to do so, they still have to accommodate you. That's what undue hardship means. That threshold means that it's recognized that it's going to be a little hard or difficult to a degree to accommodate you. They still have a legal obligation to do it. I am seeing lots and lots of this in the workplace, guys. Please do not be shy as an employee to stand up for your health. Again, and that could be mental health as well. We're seeing lots of stress leaves and burnout leaves as well. Again, get the support from your doctor. Ask your doctor for what they are recommending you do. Maybe it is take some time off, or maybe it is some sort of accommodation in the workplace. Do not be shy to speak to your employer about these things. Your doctor is your backup. Your doctor is your support, is your shield, protecting you from any negative repercussions from your employer. Finally, with respect to this issue, if your employer is giving you a hard time about a medical leave of absence, or if your employer is giving you a hard time about accommodations in the workplace, do not just take that lying down. Give us a call. Speak to an employment lawyer about your situation. Again, your employer has to be playing ball here. Very, very rarely can employers say no to an accommodation, and they simply cannot say no to a medical leave of absence. And so, again, if your employer is resisting you in that respect and giving you a hard time about these issues, you have rights, you have protections under the law. Our employment laws in Ontario are actually very, very strong and very, very supportive of employees. Don't be shy to speak with us about that situation if you're having a hard time with your employer. All right, guys, that is something I wanted to bring up today simply because it's a question and an issue that's come up multiple times over just the past couple of days. We're seeing a rise in medical leaves of absence in the workplace, and an employee needs to know what the rules of the game are in that respect. For those of you just tuning in, again, my name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP. This is a live Q&A. Go ahead and ask your questions, and I promise you I will get to them. And on that note, here come the questions. Thank you guys for your patience. First in line is Shai Noor. Can an employer deduct wages for mistakes to cover cost of damages caused by the mistakes? Shai Noor, the short answer to that question is no, they cannot. It's expected in the workplace that there will be errors sometimes. No employee is 100% error free, and so for the vast majority of occasions it's going to be expected that mistakes happen. An employee should not be on the hook for those mistakes. Now, the one potential exception I can see, just to give this question its fair due, Sharinor, is if these mistakes are repeated and constant, and the employee has been warned and warned again and warned even a third time, and these mistakes that continue to happen and the costs are significant, there is potentially some degree of liability there. So, the short answer is the devil is always in the details. It depends on the circumstances. But in the vast majority of this time, I would say 9 out of 10 times, no, an employer cannot deduct your wages for mistakes that lead to losses in terms of cost. Simply not going to happen. Illegal. You would have a right to claim wages in a situation like that, either under the Ministry of Labor or through an employment lawyer. Appreciate your question. Next up, from Facebook, Daniel asks, I'm currently transitioning from a full-time employee to a contract worker after 3 years. Is there anything I should know before I go through with this? Daniel, excellent question. We see this relatively often, and it's an interesting question because there are multiple issues at stake here. It's important to consider, just as a kind of very basic starting point, that generally speaking, employees do have more rights and protections than contract workers do, especially if you are signing an enforceable contract that potentially limits your severance entitlements or potentially limits your rights as compared to a full-time employee. Also keep this in mind, Daniel, that if you become a contract employee, quote unquote, and you are signing successive multiple contracts, well, the truth is that might not be much of a different situation as compared to a full-time employee. If you were signing contract after contract, even if those are 1 year or 6-month contracts, there's an expectation there, probably after the second or third contract signed, that this has become indefinite full-time employment. The main thing that I would look out for, Daniel, if you're signing a new updated employment agreement, right, or contract, whatever that looks like, is a contract will always favor an employer. And if you are signing a contract in 2022, I can guarantee you that there will be provisions in that contract that limit your rights and limit your entitlements as an employee, contract worker or not, and that favor the employer. And again, I'm talking mainly here about severance, about an employer's ability to change your terms of employment, about an employer's, let's say if it's a particular contract, about an employer's ability to end the contract early, about temporary layoffs. It's important that you review that contract before you sign it with an employment lawyer. And if you haven't done so already, Daniel, please reach out to us, get a hold of us. Again, you can email us at help at employmentlawyer.ca, or you can simply visit the website employmentlawyer.ca and contact us through the website. Please, before you sign that contract, make sure you speak with one of our employment lawyers. We advise employees on contracts every single day. It's the bread and butter of our work. And I guarantee you that the consultation will be worth your while, because I'm sure, again, if you're signing this contract now, that there are provisions in there that will negatively affect you, and you may not be obvious from a plain reading of the contract what issues there might be there. So listen, Daniel, give us a call, reach out to us however you like. More than happy, even myself, to review the contract with you. All right, JC 2004 X, regular viewer of these segments, thanks for tuning in again, asks, can an employer keep an employee that has been dismissed by, here we go again, JX 2004, in a follow-up post, can an employer keep an employee that has been dismissed by a union? If not, would the union have to pay the severance instead of the employer? Not sure what you mean exactly by that, JC 2004. Do you mean that the union is actually hiring this employee to be employed by the union? I'm not sure, but if an employee is unionized and they have been dismissed by the employer, your legal representative as an employee in that situation is the union. And the union can either decide to grieve the termination, meaning maybe they think for one reason or another the termination is illegitimate. The union can decide to grieve the termination or not. If a union decides not to grieve the termination, that is a very difficult situation for an employee, because effectively you have no other recourse. You cannot go to an employment lawyer as a unionized employee. You cannot start a court claim as a unionized employee. Your union is your one and only legal representative. And if they don't take on your grievance of grieving the termination, you're effectively out of luck. There's nothing you can do there against your employer. And maybe to your question, JC, it's not as if your union would owe you severance instead. That's not how it works, unfortunately. Hopefully that answers your question, JC, but if I haven't, go ahead and ask a follow-up question or clarify the question. More than happy to answer it. All right, JR asks, any advice for what one would consider a good rebuttal to be able to negotiate a higher base price after signing an offer letter? If by base price, JR, you mean your base salary effectively, or your pay, or your salary. Good question. Less of a kind of analytical legal question, because there are no particular laws surrounding the negotiation of salary, other than, of course, minimum wage. An employer has to respect minimum wage, of course. Anything over and above that, really, to your point, is up for negotiation. The practical advice I would have about negotiating a base salary is you have to have leverage in the negotiation. You have to have bargaining power in the negotiation or in the discussion. So, as an employee in a situation like that, you effectively want to make your particular position, your particular job, the work that you do, you want to make yourself effectively as irreplaceable as possible. You want to demonstrate your value to the employer in a very, very obvious way, where when you go to them for a pay increase, what an employer should be thinking there is, shoot, we don't want to lose JR as an employee. If we don't offer him this increase in salary, perhaps he'll leave and go find a better paying job. We don't want that to happen, so we need to say yes to him, or we need to make him an offer that's better than what he's currently earning. I know that's very basic advice. Don't get me wrong, JR, but really, when we're talking about salary increases and promotions and pay rises, that is the basics of the negotiation from an employee's point of view. You have to bring value to the table. You have to make yourself irreplaceable, such that they don't want to lose you. And if they don't want to lose you, they will offer you a pay rise to get you to stay. Keep in mind as well, as a very basic point, you want all of this to be respectful and professional. You don't want to get nasty as part of these negotiations. Again, more practical advice, JR, than legal advice. There are no formal legalities around pay increases, at least in the non-unionized work environment. But those are the rules of that kind of negotiation. Great question, by the way. All right. Following up, I'll address all of the fresh questions, guys, and then maybe I'll follow up with some follow-ups. JC 2004 and JR, I see you guys have followed up, but I'll give the fresh questions priority here. Chloe on Facebook asks, after being employed for almost 5 years as a supervisor, I was forced to quit due to ongoing bullying. Is this a constructive dismissal? Chloe, excellent a question, and very topical, because this is something that we are seeing lots of nowadays, unfortunately, and that is bullying and harassment in the workplace. And that bullying could come from a colleague. It can also come from a manager, from a boss, or from someone more senior than you. Broad strokes, Chloe, yes is the answer to your question. If you have been forced to quit your job because of bullying and harassment in the workplace, that may very well be a constructive dismissal. It is effectively the employer breaching the terms of employment by allowing and fostering harassment and bullying in the workplace. And that could be considered a breach of contract, which is what a constructive dismissal is. That would then allow you to seek severance. Chloe, if you were a 5-year employee, and were a supervisor in your position, you're probably looking at a significant amount of severance. I don't know how old you are, but you're probably looking at something in the range of probably 6 to 8 months as a severance package, not an insignificant amount of money. Now, as I always say with respect to these situations, everyone, the devil, of course, is in the detail. Chloe, in an ideal world, you would have brought this issue of bullying up during your employment to your management team, whoever that might have been. Maybe it was HR, maybe it was your direct manager, maybe it was the owner of the company, depending on the size of the company. You want to report incidences of bullying and harassment in the workplace. You want to report those to your employer because it triggers a legal obligation on the part of the employer. Once an employer learns and has received a report that an employee is experiencing harassment in the workplace, they have a legal obligation to investigate and to remedy the situation. As an alternative example of this, Chloe, if you never mentioned the bullying and harassment to your employer, if you stayed completely silent about it and you quit your job and you didn't even mention the bullying and harassment when you were resigning from your job, it's difficult to then blame the employer for a situation like that because they didn't know of the situation. So step number one is they need to know about the situation. And if during the course of your employment you reported these incidents to your employer and they did nothing about that, and then you had to resign in response, yes, that is a constructive dismissal. You would be owed severance in a situation like that. And again, your severance entitlements are going to be significant. We're probably talking about at least half a year's pay here, if not more. So Chloe, what I would suggest you do before any further time passes, and keep in mind when it comes to constructive dismissals, the longer time goes on, the more difficult these claims generally become. And so you want to act now, Chloe. What I would suggest is give us a call. Let's have a chat offline, phone call, whatever the case may be, and really, really get into the details of your situation. There is something here if you did resign in response to bullying in the workplace. Again, employmentlawyer.ca is the website that you can visit to get a hold of us. Otherwise, you can email us at help@employmentlawyer.ca. Again, give us a brief description of your situation. Even suggest that you spoke to me during the live Q&A about it, and we will put you in touch with the correct person. It begs a conversation, Chloe, so please reach out to us. Excellent question, by the way. All right, let's do some follow-up questions, guys, in the last 5 minutes that we've got here, going back to a couple of follow-ups. But for those of you, again, just tuning in, this is a live Q&A, employment 101, shall we call it. Go ahead and ask your questions. You've got a couple of minutes here. If you're dealing with a difficult situation at work, if you have a question about severance or a question about anything else with respect to your employment, ask it. I promise I will get to you before time is up here. But in the meantime, I think JR followed up. JR had asked about negotiating salary while you're employed with the company. I gave him some tips in that respect, and he follows up. JR follows up saying, "Remuneration. Can you discuss this on the influence of court claim if that is applicable?" JR, I'm not sure I understand the follow up. Listen, if you're dealing with a court claim, clearly the relationship is ended with respect to your employment. And when it comes to a court claim, now we're talking legal analysis and what an employee's legal rights are, what an employer's legal obligations are, and how the law works in that particular situation. That's where you get your leverage from when you're dealing with formal legal action when it comes to employment law. JC 2004 follows up. He had asked about unionized employees and whether a union might be on the hook for severance or a union might stand in the place of an employer. JC follows up and says, I mean, if for some reason a union and the employee didn't get along and they wanted to end their membership, I figured maybe that's happened at some point. Not that I'm aware of, JC, in the sense that there's really no settlement to be had there, or no compensation to be had there. I think if an employee isn't getting along with their own union, again, because the union is the one and only legal representative or representative full stop of the employee, an employee in a situation like that might have to contemplate resigning for their employment for that reason and that reason only, or otherwise kind of grin and bear it. Unions are very, very good in some respects, and do a number of things poorly on the other side of that equation. They are, of course, very good for job security. It is much more difficult to terminate a unionized employee than a non-unionized employee who can be terminated without cause at any time, provided severance is paid. Unions are also typically good for things like pay and benefits, generally speaking, especially for labor positions and technical positions. Unionized employees get better pay and better benefits, better pension contributions. What unions aren't good for are, to JC's point, enforcing employee rights when it comes to severance, when it comes to things like temporary layoffs, when it comes to things like changes to the terms of an employee's employment. In those kinds of situations, non-unionized employees are actually much, much better off. Non-unionized employees are owed significantly more severance than unionized employees are. For non-unionized employees, severance is based on age, position, and years of service, and their severance entitlements are going to be significant as a result. For unionized employees, your severance entitlements are limited by what's in the collective agreement, and what's in the collective agreement is not going to be a heck of a whole lot. One more question here in the nick of time. We've got about a minute remaining here. Helen, I think another regular viewer of our segments. Thanks for asking the question, Helen. Helen asks, can I get more compensation than average for dismissal? I reported an ethical officer 2 years ago. I imagine you mean I reported to an ethical officer 2 years ago. Helen, whether you can get more compensation for dismissal based on, let's say, bullying or harassment you reported 2 years ago is a tough one, only because it is very difficult to go back that far in time to make a claim with respect to that issue. Your issue would have to be more timely and usually around the circumstances of the termination, in order for it to be relevant. So, for example, Helen, and despite whatever happened 2 years ago, if you feel like you were let go, let's say, as a reprisal for voicing concerns in the workplace about bullying and harassment, and we can tie those two things together, yes, that might actually get you more compensation for a dismissal. But again, it has to be relevant to the termination. It can't necessarily be something that happened 2 years ago that's entirely unrelated. We will leave it at that, folks. I hope you found the use of this live Q&A today. Thank you all so much for asking your questions and tuning in. We are going to be live tomorrow as well, and I believe we're live almost every day of the week. So do tune into these segments. They're extremely informative. Go ahead and ask your questions if you're ever dealing with an employment law situation. This is a great resource to have as a starting point. And again, if you don't want to ask your question online, if you don't want to ask your question during these live Q&As, go ahead and contact us offline at our website, employmentlawyer.ca, or at help@employmentlawyer.ca is where you can reach us. Thank you all so much for tuning in. Have yourselves a great rest of the week and weekend, and we will catch you here next time. Take care, everyone.